On April 10, 2019, I submitted a writ of habeas corpus pursuant to Title 28 USC 2254 to the United States District Court of Eastern Washington. That court initially dismissed under summary judgment to the state of Washington, citing that I must exhaust state remedies. I followed up with the court indicating that there was no exhaustion of state remedies that was required under statute because the merits of the petitioner's procedural situation had already been foreclosed upon. I gave the court one additional opportunity to reconsider their summary judgment before taking the matter to the United States Circuit Court, the Ninth Circuit. And this is the letter that was added as a supplement requesting that additional reconsideration. Petitioner respectfully submits to the court for consideration this supplement to motion for petitioner-initiated summary judgment. Petitioner has submitted a writ of habeas corpus pursuant to Title 28 USC 2254. This writ of habeas corpus is an original civil action challenging the constitutionality of Article 1, Section 26 of the Washington State Constitution, which is directly and facially unconstitutional, as well as deprives the petitioner of equal rights and of equal protection under the law as a United States citizen in violation of the United States Constitution and Title 42 USC 1981. Therefore, this matter is clearly controlled under the provisions of Title 28 USC 1343 as a civil rights violation, and the district court has original jurisdiction as prescribed by law. As a result, this court has a statutory obligation to rule on the petition first and before any other courts, including the courts of Washington State. Refusal to act and fulfill this obligation will constitute a willful disregard of the petitioner's corresponding right to receive the fruits of the obligation. In accordance with Title 28 USC 2254 B1 BII 5F, the law is in agreement, as the state has in place a statute which expressly forecloses relief on the merits of petitioner's procedural situation. This ineffective corrective process by way of statutory exemption to the exhaustion of state remedies requirement agrees with Title 28 USC 1343 and Title 28 USC 1331 and confirms the district court's duty to act and rule on this petition first and before any other court, including the courts of the state of Washington. Refusal of this court to fulfill the statutory obligation imposed by law after being clearly informed and made aware of the duty would be gross negligence and wanton misconduct, of which petitioner would be entitled to any and all civil, criminal, and or financial recovery for the damages and transgression of the law resulting from the judges and court's breach of legal duties. Duties that are defined affirmatively and applied statutorily are not discretionary. The court's duty to act is imposed by positive affirmative statute. Therefore, it is not discretionary. Any attempt to dismiss or evade the duty imposed by positive law will be a willful, knowledgeable, and reckless disregard of petitioner's rights and the laws of the United States. The Attorney General of Washington has stated numerous times that hurtado has been the law of the land for over a century, which is preposterous and condescending to the true roots of our nation's freedoms and origin. I don't recall a single brave American warrior, myself included, who sacrificed his life for the cause of hurtado or the desecration of the freedoms that we Americans have been told that we enjoy. I do, however, know that the United States Constitution has been the supreme law of the land for almost 2.5 centuries. I know over 300 million Americans who look up to it every day for their lives and sustenance. I know countless myriads of lives lost, battles fought, and peace progressed, all in the name of truth and justice. Yet the Attorney General cavalierly throws our nation's foundation aside smugly in order to promote and progress hurtado as the law of the land. Shame on him and shame on the state. But in the name of justice and the light of patriotism, I forgive him for his blindness and I welcome the state back to the path of prosperity. The numerous references to case law, such as hurtado or gains, as laws sufficiently able to deprive United States citizens of their guaranteed rights secured by the United States Constitution is fundamentally flawed, as judges do not make laws, they make rulings. Lawmakers make laws, and lawmakers did not make hurtado or gains. The separation of powers exists in order to prevent a despotic or tyrannical government from ruling, as anyone serving in public office in the United States should be aware. Lawmakers did, however, make the United States Constitution and Title 28 USC 1443. Rulings are not laws, and laws are not changed by rulings. Laws are made only in accordance with the methods and manners prescribed by the United States Constitution by persons or body of persons legally constituted to do so. Therefore, hurtado and gains are not laws and have no validity or enforceability due to their unconstitutionality. The state in court has referenced to hurtado 10 U.S. 516 from 1884 as representative case law for this petition, including the claims that an indictment is not essential to the due process of law under the 14th Amendment, and indictment by grand jury is not part of the due process guarantees of the 14th Amendment. While it is true that the 14th Amendment does possess a due process clause, which may have been erroneously addressed by the hurtado ruling, it also possesses 3 other clauses. Petitioner is not applying the due process clause of the 14th Amendment to this legal argument. Petitioner is applying the privileges and immunities clause of the 14th Amendment to this petition, as clearly stated in the ground 4 of the Writ of Habeas Corpus. Indictment by a grand jury is part of United States citizenship rights guaranteed by the Bill of Rights and thus preserved by the guarantees of the privileges and immunities clause of the 14th Amendment. Therefore, Hurtado v. California and all of its progeny, including Gaines v. Washington, fail to accurately represent the petitioner's claims, and as a result are not case-worthy representation, as they address a different legal rationale than what was been brought before this court in the current petition. Again, this is an equal rights and equal protection claim. Therefore, it must withstand strict scrutiny, and the application of any other measure would be an abuse of discretion. This is a direct systemic discrimination of a fundamental constitutional right for a suspect classification under the color of state law in violation of the United States Constitution. Therefore, the compelling state interest test must be applied. Unfortunately, there is no claim that the state can make which would necessitate the unconstitutional provision of its inferior state constitution. This is simply a situation in which the state is imposing its will upon the nation in violation of federation through the willful defiance of the procedures and processes put forth by the United States Constitution as enacted by the people of the United States of America. The court seems to be implying that state prisoners are not persons in its refusal to apply the provisions of Title 28 U.S.C. 1343 because the law clearly states the district court shall have original jurisdiction of any civil action authorized by law to be commenced by any person. Such a claim is eerily similar to the one previously made by the judiciary in Dred Scott versus Sanford, in which the court claimed that black people are not people and therefore are not entitled to the civil rights or the protection of the United States Constitution. Of course, we know in hindsight how incredibly destructive and unconstitutional that ruling was to America and to American citizens. Indeed, our country has made many mistakes, but I'm proud to know that we have resolved to learn from each of them in order to be better and stronger as a result of them. We know that the question of peoplehood, which mitigated the atrocities Plessy versus Ferguson, was addressed by the United States Supreme Court in the Brown versus Board of Education case, whereby the court identified 4 elements that define a person as follows. Number 1, self-awareness. Number 2, member of a community. Number 3, established a social relation within that community. And 4, ability to own property and possess legal responsibility. It goes without saying that a state prisoner is a person and meets all of the criteria of personhood as defined by the United States Supreme Court. Therefore, any argument that state prisoners are not entitled to protection under the Civil Rights Statute, Title 28 U.S.C. 1343, is erroneous. Furthermore, in accordance with the Civil Rights Act of 1964, the civil rights of a person convicted of a crime, be it a felony or misdemeanor, are in no ways affected or diminished except insofar as expressly statutory provisions so prescribe. Civil rights especially include the right to vote, the right to due process, and the right of equal protection under the law. Since Title 28 U.S.C. 1343 makes no reference within the statute depriving state prisoners of its protection, any denial of the application of state prisoners is a violation of the law, as well as a deprivation of a right provided by an act of Congress, providing for equal rights of all persons within the jurisdiction of the United States. Judges make rulings, lawmakers make laws. Laws do not have legal authority to change by rulings. Judges have no legal authority to change the positive laws enacted by the people. Therefore, any ruling made that is contrary to the clear prescriptions of the written laws is unlawful and therefore no law at all. The law does not provide for its deprivation to any person or class of persons, including state prisoners. As a result, this court must rule on this petition first and before any other court, including the courts of the state of Washington. This court is legally bound to provide the full and equal benefits of all laws and proceedings to all persons within the jurisdiction of the United States, regardless of what state they choose to reside, in accordance with Title 42 U.S.C. 1981. Prisoners are people, and people cannot be deprived of equal rights under the law or equal protection of the law. The state claims the non-retroactivity doctrine of Teague versus Lane bars granting relief because the claims are not based upon clearly established law and would require the announcement and application of a new rule. The Constitution of the United States is based upon egalitarianism, which is the belief that all men are equal and should have the same rights and opportunities in life, and demands the removal of all inequalities among people. Therefore, all American constitutional law is founded upon equal rights and equal protection of the law principles. Any claims contrary to these theories are unconstitutional. So the state's Teague argument is completely and utterly without merit. It has no validity whatsoever and is by its very nature seditious. Equal rights under the law and equal protection of the law are very well known in established laws. Therefore, the inverse of the state's Teague argument is actually true, in that the deprivation of equal rights and equal protection of the law is not clearly established law and contrary to all the principles of constitutionalism. As a result, relief is not barred, but demanded. Granting relief is the only way of upholding the laws and principles held most sacred to Americans by American laws. I'm ashamed to know that the elected and appointed leaders of the state of Washington can claim that an obscure, unconstitutional, judge-made ruling from 1884 is more clearly established law than those enacted following the victories of the Revolutionary War and the Civil War, as well as the Civil Rights Movement of the 1950s and 1960s. I'm appalled at the state's ingratitude for the sacrifices of great Americans such as Dr. Martin Luther King, President Abraham Lincoln, and so many more who gave everything they had, including their lives, in the battle for equality. For a state claiming to be progressive and cognizant of the plight of humanity, it is disturbingly regressive in its understanding of our nation's history. the application of our nation's laws and its role in the governing of our nation's people. The following are just a few of the numerous laws and principles which clearly establish equal rights under the law and equal protection of the law. Number 1, the Declaration of Independence. We hold these truths to be self-evident that all men are created equal. Number 2, Equal Protection Clause, the 14th Amendment. No state shall make or enforce any law that denies any person within its jurisdiction the equal protection of the laws. Number 3, Privileges and Immunities Clause, the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Number 4, Comity Clause, Article 4, Section 2. The citizens of the United States shall be entitled to all privileges and immunities of the citizens of the several states. Number 5, Title 28 USC 1343, Civil Rights and Elective Franchises. Number 6, Title 42 USC, Section 1981, Equal Rights under the law. Number 7, the Civil Rights Act of 1964. Number 8, the Civil Rights Act of 1968. Number 9, Constitutional Law, Section 171, Duty to Protect and Enforce Rights. Number 10, Plessy versus Ferguson, dissent by Justice John Marshall Harlan. Our Constitution is colorblind and neither knows nor tolerates class among citizens. In respect to civil rights, all citizens are equal before the law. Number 11, the definition of civil rights. Civil rights include especially the right to vote, the right to due process, and the right of equal protection under the law. Equal protection of law is invariably treated as a substantive constitutional principle which demands that laws will only be legitimate if they be described as just and equal. Number 12, Article 1, Section 12, Washington State Constitution. No law shall be passed granting to any citizen, class of citizens, or corporation other than municipal privileges or immunities upon which the same terms shall not equally belong to all citizens. Number 13, statement by James Madison in The Federalist. Measures are too often decided not according to the rules of justice and the rights of the minor parties, but by the superior force of an interested and overbearing majority. Number 14, statement by Abraham Lincoln, the Harbinger. These lines were applicable to all men and at all times a rebuke and stumbling block to the very harbingers of appearing tyranny and oppression. Number 15, statement from Thomas Jefferson, the sacred principle. Bear in mind this sacred principle, that though the will of the majority is in all cases to prevail, that will to be rightful must be reasonable, that the minority possess their equal rights to which equal law must protect and to violate would be oppression. Number 16, are not your rights perpetrated against me not equal to the allegations of the very same crimes perpetrated by me? That was a statement that I made within the letter of introduction. We must all understand that tyranny and oppression are the enemies of constitutionalism. And when we abuse the powers that we are given in order to offend the very object which affords us our powers, we become an enemy of that object and its wrath is unavoidable. Rebellion to tyranny is obedience to God. Rebellion is always rebellion except when it is in defense of the gospel. Tyranny and oppression are the most fundamental violations of the good news. I implore you, with the greatest convictions that I can muster, grab hold of the weeds that are destroying our nation, take them by the roots of their evil, and let's extract them from our great nation. Do the right thing, discharge the duties of your office, stand for the people and not for the enemy. Respectfully and peacefully, a servant of justice, Tanoa M. Downing.